The prosecution are calling for the case of R and Evans to be retried sans the prejudicial sexual history evidence admitted by the Court of Appeal. There are two key elements the court here must assess regarding the admission of sexual history evidence: whether the Court of Appeal has interpreted the legislation correctly and the human rights ramifications of all outcomes. The Court of Appeal has misinterpreted Section 41 and in doing so allowed the defence to force prejudicial evidence through the wrong gateway. This was primarily due to the court attempting to read Section 41 in a way that was compatible with the defendant's right to a fair trial. However, what they failed to consider is the ramifications this would have on the complainant's right to privacy. But first, let's focus on the misinterpretation of Section 41. The defence attempts to use Section 41, subsection 3c, to present testimonies to the jury under the guise of demonstrating similarities beyond coincidence between the sexual conduct in the matter of question and the claimant's sexual history. However, these similarities are that X had been drinking and used certain phrases and sexual positions, yet both are unremarkable and surely coincidental. By interpreting the legislation in this manner and presenting third-party testimonies to the jury, the court is lowering the bar for similarity, resulting in the impugnment of the claimant's character. Critics have since said that Evans shows a shift in attention from probative credibility to moral credibility, which can be highly distracting for the jurors. These testimonies act only to impugn the character and credibility of the claimant and undermine her claims, and therefore they should not have been presented in court. The prosecution is calling for a retrial whereby the testimonies of Owens and Hughes are not presented to the court in this manner, if at all. Through adducing this evidence, the Court of Appeal have set a dangerous precedent which almost entirely disregards the motives behind the imposition of the legislation. One of the key aims of Section 41 was the attempt to rebut the twin myths, as these myths encapsulate a regressive way of thinking centred around the connotations linking chastity and truthfulness, observing unchaste women to be untrustworthy. Anne-Marie Sue observes that adducing evidence of this nature draws the focus of the jury to the respectability of the female claimants, thus causing a shift in legal and moral blame from the defendant. Commentator Claire McGlynn stated that there is no probative connection between consenting to one person and consent to a different person. If there is no probative element to this evidence, surely its only purpose would be to impugn the character of the claimant. Now, let's discuss the elements that the defence argue are so similar that they could not be coincidental. X had sexual relations with Owens and Hughes and frequently used similar language and has been described as an enthusiastic participant in all sexual encounters. The parallels between the relations X had with Owens and Evans are, upon first glance, overwhelming. In both circumstances, the respective couples met at a nightclub, engaging in similar sexual positions and offering the same words of enthused encouragement. Both situations saw both parties intoxicated, yet the extent of the intoxication can be called into question. But that's where the parallels end. One of the core aspects of the subsection 3c gateway is that the behaviour must be so unusual in order to qualify for these exceptions. It's absurd that the Court of Appeal granted leave for the evidence to be admitted, as the similar factors are so mundane, so unremarkable, and easily constitute a coincidence, and therefore surely is not encapsulated within 3c. Owens had said that X never appeared that drunk, and yet frequently struggled to remember the events of that night before, demonstrating that she is prone to memory loss following a night of drinking, but it is not indicative of her level of intoxication. This contrasts to the way she was described here, Mr. Burry describing her as extremely drunk and MacDonald referring to her as sick. If at the time she had engaged with Owens in a sexual manner she had not been outwardly drunken, surely it cannot be compared to this case where she had been described by two individuals as extremely drunk to the point of being sick. R and Bree in 2007 set a clear precedent regarding consent whilst drunk, stating that the complainant is incredibly drunk but remains capable of choosing whether or not to have intercourse and in drink agrees to do so, this would not be rape. The CPS declares that a complainant does not need to be unconscious, however, to lose their capacity to consent. And if we're following the facts presented by both MacDonald and Burra, then X was outwardly too drunk to consent, something that was not evident in the facts provided by Owens or Hughes. If X frequented bars, drank alcohol, and often partook in casual sex, then how can it be explained that she felt so unsafe to the degree where she felt it necessary to alert the police on this particular occasion, but not the aforementioned encounters? Clearly this would harm the defence, thus begging the question, why did the defence want to present it to the court? Once again I refer to the twin myths. The defence are relying upon the jury, factoring their prejudices to arrive at a biased verdict. Upon the jury to factor their prejudices for them to arrive at a biased verdict, one which reflects the archaic connotations between chastity and believability. The case of R&T was seen as broadening the gateways to permit evidence extended to historical sexual encounters between the complainant and the defendant. However, here, the Court of Appeal expanding the scope of the legislation to include sexual encounters with third parties, and through doing so, the trial starts to work to the detriment of the complainant, progressing to placing more emphasis on moral credibility than probative credibility. As outlined by Professor Claire McGlynn, the precedent set by evidence does not simply open the floodgates but risks a tsunami. through threatening to become an open invitation to the defence to trawl through a complainant's sexual history, seeking similarities. This draws a dangerous line, expanding the requirements for admissible sexual history evidence to an unprecedented degree. However, I do recognise that there should not be a blanket ban on all sexual history evidence, as this does run the risk of infringing upon the defendant's right to a fair trial as per Article 6 ECHR. The courts must abide by Section 3 of the HRA, which requires primary legislation to be read and given effect in a way which is compatible with the Convention rights. In the case of R&A, Lord Slynn attempts to strike a balance that upheld the ECHR and the respected the legislation, remarking that subsection 3C was very restrictive if read literally. The House of Lords concluded that the interpretation rules of Section 3 HRA could permit evidence about previous relationships between the claimant and the defendant, believing it necessary for the jury to make a fully informed decision with all relevant context. Had the evidence not been adduced, the defendant's right to a fair trial as per Article 6 of the ECHR would have been violated. This precedent insinuates that if the sexual history evidence was necessary for fairness, then it is admissible, meaning the evidence would have to be exceptionally relevant. Applying this to the case of Evans, barring detailed evidence through 3C wouldn't impinge upon his rights to a fair trial due to the lack of similarities, rendering it almost entirely irrelevant. Whilst it could still be admitted through Section 41, subsection 2b, the extensive detail of the testimonies would not be required in order to provide the jury with relevant and necessary context. However, we'll look at this solution in further detail later. Whilst it's imperative that the defendant's Article 6 right to fair trial is respected, it's equally important that a complainant's Article 8 right to privacy is. As Lord Slynn recognised in the case of R&A, there is an obvious conflict between the interests of protecting the woman and of ensuring the fair trial. In the 1975 Hellebron report, they expressed concern about the extent to which, in a rape trial, the personal history and character of a rape victim can be introduced, and said that the sexual history of the alleged victim with third parties is of no significance, and rarely likely to be relevant to issues directly before the jury, recommending that the admission of sexual history evidence be strictly regulated. This was largely to be seen as resolved by the YJCEA. However, this case threatens to broaden the gateways to the extent where it could directly undermine the legislator's intention. The report recognises that it's rarely likely to be relevant for the jury to hear, and thus begs the question, how can it impede upon the defendant's right to a fair trial if the evidence is hardly relevant? The argument that excluding this evidence would render a trial as unfair is clearly one rooted in the defence's desperation to evoke the twin myths and impugn the claimant's character. We also must assess the foundational principles of criminal evidence, expertly identified by Paul Roberts and Adrian Zuckerman. These set the foundations for the structural framework of criminal evidence as a whole. There are only two principles that have striking relevance to this case: the principle of protecting the innocent from wrongful conviction and humane treatment. The former could potentially be applied to the defendant, with the Court of Appeal's verdict of allowing the presentation of this evidence demonstrating that the judges felt it important that the jury hear it in order to deliver a just verdict. Lord Slynn is quoted as saying that Section 3C, if read literally, is disproportionately restrictive. However, the issue of context required in order to protect this right can be satisfied by admitting the evidence through subsection 2b. Again, this allows context without excruciating and humiliating details for the complainant. This links to the principle of human treatment, which states that the state should respect the inherent dignity and exhibit appropriate regard for the welfare of every person over whom it exercises jurisdiction. Over 80% of women who are raped don't report it, and many crediting the humiliation as the principal reason. It's been described that appearing in court is worse than the rape itself, hence the dire need for the protections around the admissibility of sexual history evidence. Roberts and Zuckerman recognises that the rules of evidence and procedures that are in place place these additional restrictions, partially fulfil the principle of humane treatment, and therefore should be respected. Section 41 is an integral provision enacted to ensure that the complainants are protected from inhumane invasions of personal privacy, and therefore is an integral provision enacted to uphold this vital principle. Subsection 2b is a harmonious compromise that ensures both principles are upheld satisfactorily. The solution is simple. As briefly mentioned, the court should have focused on Section 41, subsection 2b, that refusal of leave might have the result of rendering unsafe a conclusion of the jury or the court on any relevant issue in the case. It's clear upon evaluation that the testimony should not have passed through the gateway found in 3C, as there are far too many differences between the respective sexual encounters, and the mundane similarities that are definitely coincidental. 2B, however, may permit some of the evidence, but in a much broader sense. One could argue that the jury needed to know that X was inclined to engage in casual sex, however, is not required for extensive and humiliating detail to be presented so publicly. Through focusing on 2B, the conduct of the defendant would be on trial as opposed to the private life of the complainant, thus upholding their right to privacy while still respecting the defendant's right to a fair trial. Through using this gateway, the evidence is not that which will impugn the character of the claimant, but one which will provide context. thus keeping the defendant and his conduct at the centre of the trial. To conclude, the prosecution are appealing to the Supreme Court to allow our appeal and to overturn the dangerous precedents set by the Court of Appeal and their misinterpretation of Section 41 of the YJCEA. In attempt to protect human rights of the defendant, they have neglected the human rights of the claimant, going as far to disregard the safeguards implemented by Section 41. Thank you.